In this podcast, um, I'd like to discuss with you this thing. What do you think about this notion of public domain, where something used to be protected by the copyright law, and then after a period of years, it enters the public domain, um, which is great, anyone can use it, but there's a caveat to it. So let's talk about it.
Yeah, okay, so we're talking about copyright. Now, typically, as we talk about in the class, copyright in many countries, 50 years after you die. So if you create something, you write something, piece of music, for 50 years after you die, your family, your estate owns that, and then after that, as you say, it becomes what we call public domain. Anyone can use it. It's longer in the United States and some other countries. Partly that's to do with the Disney Corporation, who wanted to protect some of their characters. Probably we'll come back and talk about that. So this is this idea of public domain, that after a certain amount of time, something becomes free for anyone to use. You're not breaking intellectual property law when you...
So recently, public was very excited that, for example, Winnie the Pooh went into the public domain. Everyone got excited, um, and there was a lot of confusion. Like Winnie the Pooh, because many people never read the book; they just watched the movie, so the cartoons by Disney. So they thought that went into the public domain, but in fact, it was the book, the original book, which went into the public domain, and the cartoon is still in the property of Disney, right?
Yeah, so this is where it gets a little bit more complicated, right? Often you might have had a character like, say, Winnie the Pooh, some of the other famous characters, they came from an original book, and then someone else came along and made a movie version which made it even more famous. So when we're thinking about what has actually come into the public domain, what are you counting? Are you counting from the original book, which might be decades older, or are you counting from the famous Disney version, or when it was made into a movie that was very popular and so on? And so be careful about the idea of setting up your Winnie the Pooh t-shirt printing business. Check which character might be in the public domain and what might not be, because you could accidentally be using the Disney version and they're saying no, we still own that.
But even the cartoon, at some point, I think it's maybe 120 years since it's a product by a corporation. 120 years after it was first made, it will enter into the public domain. So it will be long, a long time into the future. But even then, this yellow bear wearing a red shirt might not be in the public domain. So how does that work?
Yeah. So you've got to understand the difference between the original character, say, written in a book, described in a book, and then a particular version of that character. So what you're talking about there could be the Disney version of that character, which made it more famous, because more people watch movies than they usually read books. That version is still copyrighted, or even could be a different type of intellectual property, trademark, which is where it's kind of like a brand of a company. Mickey Mouse is another example of this, right? So let's talk about what's happened with Mickey Mouse, because it's a similar example. The very original version of Mickey Mouse, in theory, that is now public domain. The copyright has run out.
On the cartoon.
On the cartoon. But Disney might say, well, hold on a minute. Mickey Mouse is such a famous character for us, for our business. It's in the theme parks. It's everywhere on Disney merchandise. That actually we still own that. That's a symbol of our company, right? And so again, we're into another call a grey area of whether that's actually something you might be able to use, or the Disney lawyers will contact you.
And I think you're referring to that cartoon from 1930s, Mickey on something Steamboat,
Yeah.
Steamboat Willie,
Yeah,
and Mickey there looked quite different from the Mickey that is on Disney merchandise. So therefore, you can use the old version of Mickey, but not the new version
Right.
of Mickey.
in theory,
Mhm.
in theory, because this is quite new. I think it was only last year or the year before that that first version of Mickey Mouse, Steamboat Willie you're talking about entered the public domain. There hasn't really been a case yet, a legal case that's tested that. So this is one of the things we need to remember when we're talking about intellectual property law, that in many ways cases, examples, create the law, especially in Western countries like the United Kingdom, where I'm from, the United States. The cases make the law. So when Disney sues someone, takes someone to court over using that original version of Mickey Mouse, that is going to create the law about whether they still own Mickey Mouse or not. So we'll see.